headquarters officers with me in a physical mode. It remains for me to thank our principal district judge to nominate me as one of the member in the study circle, along with two other sister judges, and giving me this opportunity. The two officers are there. Please. Next is convenient. Chair. So today we'll have a small overview regarding the new Evidence Act. Actually, we all know we must have already gone through the basic changes in the Evidence Act. However, it will be a recollection as well as to make ourselves convenient with the changes that has been brought by BSA, Bharatiya Sakshya Adhiniyam 2023. This act is going to replace a century-and-a-half-year-old Indian Evidence Act of 1872. And we have been, as judicial officer, day in and day out, well convenient and versed with using the provisions like section 21, 27, section 30 and other provisions for contradicting the witnesses, 144, 155. Other provisions in the Evidence Act, which we have to now renumber. It may, basically we may feel that the new act may be just old wine in a new bottle with renumbering of the sections, but that is not true. See, in a food, we are going to add a pinch of salt. It may change the entire texture of the food. Like that, this act has brought in few changes, but it is going to be a real challenge for the judicial officers as well as the litigants. Day in and day out, we have to go through the Evidence Act and its applicability when we are recording evidence. On the one hand, we have the substantive law which describes the rights and liabilities of the parties. On the other hand, the procedural law. This Evidence Act is going to be link between these two acts, which makes these two substantive and the provisional law operational. When someone wants to establish the rights and liabilities, they follow the procedure and come to court. But ultimately, we decide the rights and liability in accordance with the Evidence Act, whether they are proved, disproved, or not proved the case. So, Evidence Act is now going to be very lifeline in our functioning. So before I start with the new act, let us see the preamble itself. In the old act, the preamble would say, whereas it is expedient to consolidate, define, and amend the law of evidence, it is hereby enacted as follows in 1872. So now today, when we see the new act, the preamble, we give a different picture. The purpose of the act would say, be enacted, an act to consolidate and to provide for general rule and principles of evidence for fair trial. We have been always insisting for fair trial, always. Maybe during the colonial period, when they thought the purpose of Evidence Act was not for fair trial. But today we have brought in fair trial in the Evidence Act. So procedural laws are there for fair trial. Now Evidence Act is also has been enacted in a manner with the purpose and object to bring fair trial, to render fair trial and justice to the litigants who come to court. There are changes in the arrangement of the sections that we can go through normally by seeing what is the old section is being replaced with a new section. I did not waste time on that. But the important thing is, initially the section 3 interpretation clause, now it has been advanced to one section by 2 and is renamed as definition clause. And it defines all those concepts or words which have been interpreted in the old Act and defined now. In this definition, there are two important changes which will be very important for us, which is going to bring a see-through change during the evidence process. One is section 2D. This D we can remember for document. And one is 2E, which is in evidence. When we compare this old Act and the new Act, the document in the old Act is interpreted as means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. And it gives illustration of 4 illustrations of that. Now we come to the new Act. Document says means any matter expressed or described or otherwise recorded, which is a new word that has been introduced in the new Act. So it need not be always inscribed or recorded. It says on otherwise recorded upon any substance by means of letter, figures, or marks, or any other means, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. And here it is very important and includes electronic and digital records. Previously, document did not include this electronic and digital records. Now it includes electronic and digital records. See, on the face of it, if we see if it is record, it will be like a record, like a paper record, or any documents are be produced in the court. But when we go to the illustration, the 5th illustration, 6th illustration, will give a different color to this electronic record. And an electronic record on email, server logs, documents on computers, laptops or smartphones, messages, websites, locational evidence, voice messages stored on digital devices or documents. So when the document is definition, it says electronic and digital records. When the illustration, it gives devices. So the entire device will be in our document. It is not necessary that what is printed out or what has been taken out from the computer is alone an electronic record. The document brings in the electronic record device itself as a document inside the concept of document. Previously, the electronic evidence was electronic evidence. It was not electronic document, it was electronic evidence. Because in the old Act, while defining evidence, in class 1, it says all documents, all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. Now, if you see, there is a change in evidence. It says all statements, including statements given electronically, which the court permits. So this is added in the evidence, in the definition of evidence. So we need not expect or ask the party to come to the court and give evidence. It is the discretion of the court which the court permits. So electronically, the party can give evidence before the court, or they can be a witness before the court in relation to the matter. In second class 2, the old Act, it says all documents, including electronic records, produced for the inspection of the court. So in the previously, the electronic records was only introduced in the section evidence, the word defining the evidence, not in the document. So previously in the document definition, electronic record was not there. This time in the new Act, the electronic record and digital records, both electronic and digital records, both are being brought under the definition of documents, as well as in the evidence also, it includes both electronic and digital records. That is what may come. Because in Naujat Singh case, the Honorable Supreme Court had a view that electronic records will also be a documentary evidence. So we can invoke secondary evidence for that. Section 65, we can say. In the old act, we know 65 says when cases which secondary evidence relating to documents may be given. So when electronic evidence was not defined as a document in the Evidence Act, it was only a part of evidence, definition of an evidence, not a document. In Navjot case, the Honorable Supreme Court said it can be treated as a document and secondary evidence being given. But what the subsequent case in Akbar and Arjun Pandit case, it was said that section 65B, 65A and 65B is a code separately for electronic evidence. It will not be a document. So you could not use secondary section 65 for letting in evidence using electronic documents, electronic records, because it was defined in the evidence, in the meaning of evidence, and 65 and 65A and B were given how to produce or admissibility of electronic evidence. Therefore, the section 65, which is the case where under circumstances in which we can let in secondary evidence, was not applicable to electronic evidence then. But now this has gone a see-through change, because document has been now defined under electronic evidence and digital records are defined under documents. So section 65 will be now applicable. So this is one of the major change we have to keep in mind, where the electronic evidence has to now rule our judicial system when it comes for evidence. And the other section, one other important section would be previously section 30. Accomplice evidence. There was a bar for relaying a confession statement of a co-accused against another accused. And it is required that both have to be tried jointly if the confession of an accomplice has to be relied upon. This was a difficulty when one of the accused absconds. They cannot split up the case. Now the new Evidence Act provides that exception to that. The new Act section 24. Will help us to split up the case when the co-accused is absconding, and we can place reliance upon the confession of the co-accused. When more persons than one are being tried jointly for the same offense, and a confession made by one of such person affecting himself and some other of such person is proved, the court may take into consideration such confession as against such other person, as well as against the person who makes such confession. The explanation too is important. A trial of more persons than one held in the absence of the accused who has absconded or who fails to comply with the proclamation issued under section 84 of the Bharatiya Nagarik Suraksha Sanhita 2023 shall be deemed to a joint trial for the purpose of this section. So this has to be read with our proclamation proceedings under the new CRPC. CRPC now provides that even when the accused is absconded, you proclaim, you can pronounce judgment. So it has to be, this evidence act to be in consonance with that provision. So section 30, now new section 34 has been amended, so that when in case of there is no need for joint trial when there is a accused is absconded, and one important thing is he has absconded or who fails to comply with the proclamation issued under him. So this is one other change in the Evidence Act, which will be very useful for criminal courts when we deal with accused who are absconding and need to be tried jointly. The Hague Declaration, now it has been renumbered as section 26. So we usually follow we remember 32 as the Hague Declaration. So it has been renumbered as 26. That there is no change in as far as the provision is concerned. Next, one of the important changes that will be a challenge to us is this electronic evidence and documentary evidence. Section 59 in the old Act defined oral evidence, proof of facts by oral evidence. It says all facts except the contents of documents or electronic records may be proved by oral evidence. So that it was differentiated as documents or electronic records. In the new Act, it is renumbered as 54. All facts except the contents of documents. So because document is already defined, electronic record is defined under document, they removed that electronic record separately. So contents of document may be proved by oral evidence. Section 61 of old Act, proof of contents of document, is now renumbered as section 56. 61 is renumbered as 56. The contents of document may be proved either by primary or secondary evidence. And what is primary evidence? Old Act 62 says what is primary evidence. Primary evidence means the documents itself produced for inspection of court. Where a document is executed in several parts, each part is primary evidence of document. Where a document is executed in counterpart, each counterpart be executed by one or some of the parties only. Each counterpart is primary evidence against the parties executing it. Explanation 2. Where a number of documents are all made by one uniform process, as in the case of printing, lithography, or photography, each is primary evidence of the contents of the rest. But where they are all copies of a common original, they are not primary evidence of the contents of the original. This is the old Act. When you come to 57, the new Act, it is having 7 explanations. Previously, there was only 2 explanations. Now there are 7 explanations. 5 is added to this. As far as explanation 1 and 2, it is almost the same. The explanation, explanation part 1, explanation 1 to 3 are the same. Explanation 4 to 7 are important. where any electronic or digital evidence is created or stored, and such storage occurs simultaneously. Just note this point: simultaneously or sequentially in multiple files. Each such file is primary evidence. So electronic or digital records created or stored, and such storage occurs simultaneously or sequentially. So now electronic record can be stored anywhere simultaneously or sequentially. Then everything will be a primary evidence. We cannot say he has got the mobile phone or he has got the computer, he has created the document. The other person who has received it, it's say, for example, if you are booking a railway ticket, immediately after the railway ticket is booked, the message of booking the ticket is sent to the traveler or a customer, as well as it also recorded in the railway server. So this is simultaneously or sequentially it is recorded. Say we have mobile phone, there is cloud storage. We download a document or we create a document, we store it in the mobile phone, or say we receive some message through WhatsApp or some email, we store it in the mobile phone, the photograph. Simultaneously, it is get stored to the in our cloud storage. So the storage made in the cloud as well as in the mobile phone or the system device will now be primary evidence. Both can be used. One cannot say only the mobile phone or the system is the primary evidence. What is stored in the cloud storage is the secondary evidence. Both will be treated as primary evidence under explanation 3. Explanation 4. And another thing is where an electronic or digital record, explanation 5 says, is produced from proper custody, such electronic and digital records primary evidence unless it is disputed. So now electronic records should be produced from the proper custody. Who is proper custody? That is a difficulty we are going to face. In a case of dispute between husband and wife, husband produced the mobile phone or the wife, or wife produced the mobile phone of the husband. Who is having custody? So only if it is produced from the proper custody, it can be used as primary evidence, and it should not be disputed. If it is disputed, it loses the value of primary evidence. So one thing we have to remember is it should be from the proper custody. The device should be from the proper custody. Sometimes the husband can or a wife can use the other person's mobile number for the purpose of the litigation. He has got this received or he is chatting with some other person. If you produce wife, the husband produce the wife's mobile phone, can we take it as primary evidence? It can be also treated as secondary evidence. That will come later. So it cannot be used as a primary evidence. But there is other dispute. One cannot, under the IT Act, you cannot tamper with the electronic device of another person. You cannot take the information from the electronic device of another person. It is an offense, and the person who does so is liable for compensation, heavy compensation. So subject to that, they can produce this evidence, and they can face whatever prosecution under the IT Act differently. Now, explanation 6, where a video recording is simultaneously stored in electronic form, transmitted or broadcasted or transferred to another, each of the stored recording is a primary evidence. So I take a video recording. We go to a picnic spot. We take a video. Say we can say some murder is happening in the road. Someone is taking a video recording. Immediately he forwards to YouTube, or he forwards to a friend. He forwards to someone else. So whatever is broadcasted or transferred to another, this also becomes a primary evidence. It cannot be treated as secondary evidence. So primary evidence now circulates with anyone. It can be with anyone. I take a mobile and circulate to all the judicial officers. Everyone will be having a primary evidence with you, as far as electronic record is concerned. So explanation 6 gives a enormous, more broad explanation for primary evidence as far as electronic record is concerned. Explanation 7, where an electronic or digital record is stored in multiple storage spaces in a computer resource. Each such automated storage, including temporary files, is the primary evidence. So we may not know. We may have a mobile phone or a computer. When you say in documents, when you are creating, using a document file, there is a provision for backup. Even though we lose the main file, the backup file will be automatically stored. Sometimes what happens, we switch off the computer suddenly or due to power cut. When you switch on and we try to open the office document, it will say this file has to be restored. So where it restores this file from the temporary storage. So this temporary storage, which is normally called as random access memory, which the computer uses, that can be used as a primary evidence apart from the original file. If someone is creating or someone is taking some file from a computer or doing some operation in the computer and suddenly shuts down the computer because some other one watching or someone, even if recover the computer and take put it to forensic examination, the forensic department is able to collect any material from this temporary storage. It will also be treated as a primary evidence. We cannot say this is a temporary storage, there is no file. There is no need to be a particular file for that. This temporary storage itself can be considered as a primary evidence for that particular issue. Say it may happen in copyright violations, what do you call this, IP Act and all, it will be used. So these are the new explanations as far as electronic evidence is concerned, which will give its primary, the status of primary evidence for electronic evidence. And coming to secondary evidence, old section 63, new section 58. Previously, we had secondary evidence included only 5 categories. Those 5 categories are as it is retained. Apart from that, 3 more categories are added. And this is going to be more confusing for us. 58 class 6 adds oral admissions. So oral admissions will be secondary evidence now. And we should say this will be a bit contrary to the section 22, old section 22 now, which already provides for older evidence. Now 20. In the new act, you can see section 20, where it permits to give oral evidence regarding the documents. Old sections 22. When oral admissions as to contents of documents are relevant, section 20, oral admissions as to the contents of the document are not relevant unless and until the party proposing to prove that them shows that he is entitled to give secondary evidence of the contents of such document under the rules hereinafter contained. This is the new act. Or unless the genuineness of the document produced is in question. When the genuineness of the document itself is questioned, letting an oral evidence to prove the genuineness of a document, genuineness is doubtful. Then we are going to let in oral evidence to prove a genuine documents of a document which genuineness is questioned, secondary evidence. Then it is going to be some difficulty for us to decide, which we have to get over. In the old section, the genuineness section 22 of the old act. It will read, oral admission as to contents of documents are not relevant unless and until party proposing proof shows that he is entitled to give secondary evidence of the contents of the document under the rules hereinafter, or unless the genuineness of the document produced in the other case. That's a mistake. Genuineness of the document. Now, this oral evidence has become separately as secondary evidence. Previously, it was not there. Secondary evidence now, oral evidence admissions can be oral admissions. Oral admissions can be let in a secondary evidence now. So this is going to be a real headache for us. If someone will say he has orally admitted to me of receiving money, giving money, etc., as a secondary evidence, so we have to adjudicate them. Then written admissions. Secondary evidence can be given. Written admissions. Secondary evidence of a person who has examined a document, the original of which consists of numerous accounts or other documents which cannot conveniently be examined in court, and who is skilled in the examination of such documents. So this class 8 under section 15, 8 new act provides expert, it is like an expert opinion. say there is a company where they have a lot of transaction and documents. So we cannot examine all those documents. What section 58(8) clause says is an auditor who has actually examined those documents can now give secondary evidence regarding the facts of that case. So this is another improvement as far as secondary evidence is concerned, which we have to see. Now, another important improvement is in section 65, old section 65, where secondary evidence may be given. Previously, it was having A to G. Now we are having A to G with explanation 1 to 4. Explanation 1 to 4. So now coming to the electronic evidence admissibility, previously we have only 65A and 65B. Now 61, electronic digital evidence records. Nothing in this adenium, it is starting with a non-obstinate class. Nothing in this adenium shall apply to deny the admissibility of an electronic or digital record in the evidence. So nothing in this act can deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic or digital record, and such record shall, subject to section 63. 63 is which is following now. Section 63 has the same legal effect, validity, and enforceability as other documents. So like any other document, electronic records, digital records can be produced. And nothing in this adenium shall apply to deny the admissibility. So denying the admissibility of the document based on some other provisions in this act is not permissible. Subject to section 63 alone. And section 62, the contents of the electronic record may be proved in accordance with the provisions of section 63. So 61 says, nothing in this act can bar the admissibility of electronic or digital records subject to section 63. And 62 says, the contents of electronic will be proved in accordance with the provisions of section 63. Previously, we had 65A, which is the contents of the electronic record may be proved in accordance with the provisions of section 65B. Now, the admissibility of electronic records is given under section 63. This is equal to section 65B. Section 63 is now equal to section 65B. Anything contained in this adenium, any information contained in electronic record which is printed on paper, stored, recorded, or copied in optical or magnetical media or semiconductor memory. Semiconductor memory has been added in the devices. Memory which is produced by a computer or any communication device or other stored. Now we see there are two non-obstinate clauses. Section 61 says nothing in this adenium shall apply for the admissibility. And 63 says, notwithstanding anything contained in this adenium, any information contained in electronic record which is printed on paper, stored, recorded, cannot be produced without the certificate. Whether certificate is necessary or not. One will say this is a primary evidence under the documents. Under 61, which is a primary evidence, I can produce the entire device. Now under 63, one other party will say, see, under 63, nothing, not within anything under this act, you have to produce a certificate. So we have to get over it when it comes for evidence. The other conditions are the same. This is the main changes which has been brought in the electronic evidence as far as the new. Notwithstanding anything contained in this adenium, shall be deemed to be an also a document if the conditions mentioned in the section are satisfied in relation to information on computer and shall be admissible in any proceedings without further proof of or production of original as evidence or the contents of the original or of any facts stated therein, of which direct evidence would be done. The conditions about the supplement recipe computer shall be following, namely in section in the subsection. Nothing contained, anything contains any information contained in the electronic record semiconductor which is produced by a computer or any communication device or otherwise stored, recorded or copied in electronic form, carried up to etc. computer output shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information computer in question and shall be admissible in any proceedings without further proof or production of the original as evidence or as contents of the original or of any fact stated therein, of which direct evidence would be admissible. Second, 63.2. The conditions referred to in subsection 1 in respect of a computer output shall be the following, namely the computer containing the information, etc., during the set period process the functioning. At 61, sir, shall apply the 63 la irukku adhe da shall da irukku information in electronic record. The condition about the substitute respect to the computer output shall be the following. In a condition shall be the following in the
section 63 subclass 2 la vandu documents and the document
notwithstanding anything contained in this adenium, any information contained in electronic record which is printed on paper, stored, recorded or copied in optical or magnetic media or semiconductor memory which is produced by a computer or a communication device or otherwise stored, recorded or copied in any electronic form shall be deemed to be also a document. First is the documents of anything stored, etc.
62 la naya aya vandu padichathu 62 la the content
the contents of electron may be proved in accordance with the provisions of 63.
The documents ellame mandatory ah நம்ம certificate கொடுக்கணும் அததா section
62 only says 62 says the contents of electronic records may be proved in accordance with the provisions of section 63. Section 63 certificate கொடுக்கணும்னு சொல்றாங்க. இது may be proved ன்றதுக்குனால 62 தான் சொல்லுது, but that the same provisions there 65 8. The electronic may be proved in accordance, but the ruling is we have to produce 65 if they are producing a secondary evidence, electronic evidence. But now is previously electronic evidence was not a document. There is no definition for primary evidence. Electronic evidence is not made as a primary evidence. All these electronic devices produced பண்ணாலும் இது பண்ணா we have been using 65B. Now primary evidence entire device produce பண்ணனும் 65B வேண்டுமா வேண்டாம்? That is a question which has to be decided by the authorities.
Section 63 subclass 4 in any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things shall be submitted along with the electronic record at the search instance where it is being submitted for admissions only. So அதிலேயே section 63 subclass 4ல வந்து எதெல்லாம் நம்ம வந்து கோர்ட்ல வந்து பிரைமரி எவிடன்ஸா நம்ம போடுறோமோ பிரைமரி எவிடன்ஸா இல்லாத மற்ற எல்லாத்துக்கும் நம்ம வந்து சர்டிபிகேட் ரிசீவ் பண்ணணும்னு தான் சொல்றாங்க.
Now question is, madam, there's a two notwithstanding anything contained certificate compulsory. 63 notwithstanding anything contained. If you want to let in electronic evidence, 65B becomes necessary. 63(4) now becomes necessary. If 61 nothing in this adhiniyam shall apply for admissibility. So as far as admissibility, no bar, you produce it. You cannot question the admissibility subject to 63 solranga. 63 notwithstanding anything in this adhiniyam, you have to produce this certificate. So this is going to with certificate.
My understanding is that it is not mandatory.
But shall any proceedings where you decide to give a statement in evidence by virtue of this section, a certificate doing any of the following things shall be submitted along with the electronic record. Electronic record, we saw the device is also an electronic record. The illustration varumbodhu நம்ம print out எடுத்து கொடுக்கணும் 65B வேணும், you are printing taking a print out from the computer போது 65B வேணும் நம்ம we can insist. கேக்குறது இல்ல. இப்ப நம்ம ஒரிஜினல் எவிடன்ஸ் வருதுச்சுனா இப்ப everyone started producing the device itself. நம்ம எவிடன்ஸ் எடுத்து போய் நம்ம பாப்போம். Today we can see what is there in the mobile phone. You keep it switched off for 2 days, its battery goes. அப்புறம் இல்ல party if you insist upon the primary evidence other side. இப்ப அத வந்தாவோட வந்து even if we receive the device itself, we have to take a backup at the 65B certificate order, we have to keep it. Now after the trial ends, it goes to the appeal. நம்மட்ட செல்போன் மொபைல் ஆன் பண்ண ஆன் ஆகும். அதுல இருந்த contents we have to necessarily take backup and store it along with the 65B certificate or 63(4) certificate.
அதனால தான் பிரைமரி எவிடன்ஸ்லயே எல்லாமே கொண்டு வந்துட்டாங்க. நம்ம எதெல்லாம் ஷேர் பண்றோமோ எல்லாமே பிரைமரி
யார்ட்ட வேணாலும் இருக்கலாம்.
யார்கிட்ட வந்தாலோ எனி ஸ்டோரேஜ் பிரைமரியில இருந்து வந்த ஷேர் பண்ண எல்லாமே பிரைமரி எவிடன்ஸா கொண்டு வந்துட்டாங்க.
So these are the major changes. Electronic evidence, it may be a task for us while deciding admissibility and designing. The emails they are now forging. Someone email they can send you.
They could order and
send it. Gmail and AI வந்த போது இப்போ see video device produce பண்றாங்க. பேசாத AI வச்சு இப்ப பேசி வச்சிட்டு கொண்டாங்கன்னா அத வந்து the thing is now we have to send it for forensic. So இல்ல இப்ப other side question அத admissibility வரும்போது dispute பண்றாங்க. In the explanation if it is disputed genuineness, then it is a problem. So every case we are going to send it for forensic. போறாங்க இப்ப எல்லா கேஸும் forensic போனாங்கன்னா how can we dispose the case? பக்கத்துலயே சீட்ல forensic இருந்தா உடனே பார்த்து சொல்லிடலாம். We send it to forensic department. Whatever that is. இப்ப அவன ஒரிஜினல் எடுத்துட்டு வருவான். See, my friend has got this is the original. He has got this is the original. So which we can believe. So it is going to be a real difficult task for us. ரெண்டு different set of ஒரே எவிடன்ஸ் கொண்டு வர போறாங்க.
Stating that I have not sent the message, this is the only sent. The person who received also, you could also alter.
ரொம்ப டிஃபிகல்ட்டி அதான். இல்ல இப்போ இருக்கு. இல்ல இப்போ நீங்க சொன்னீங்கன்னா இப்போ இருக்குனா அப்ப previously we will see the original source. அப்போ வந்து யார் அனுப்புனானோ அந்த சோர்ஸ்ல கிரியேட் சோர்ஸ் ரிசீவ் சோர்ஸ். இப்போ என்ன any storage simultaneously and sequentially it is stored anywhere, you can produce it as primary evidence. Appo still we are going to face some issues. Shall be, but adle one of the oral evidence statement, you want to give statement on that na certificate of the subclass 4 63
containing the statement and describing the man
standard in which it was produced.
Produce, அப்போ வந்து 65 is certain. 63 ல 64 ல அது வந்து. In any proceeding where it decide to give a statement in evidence, you want to give oral statement in evidence, by virtue of this section, based on this section, a certificate proving any of the following things shall be submitted along with the electronic record. And such each instance where it is being submitted for the, when they identifying the electronic record containing the statement and disclaim the manner, the certificate form நமக்கு கொடுத்துறாங்க. Previously there was no form. Now we have a schedule in the month.
ஆமா.
Schedule, certificate form. So this will make us easy. முந்தி எது வேணாலும் எழுதி கொடுப்பாங்க. Now this certificate will make it easy for us to admit the document. Reliability is a different question.
பார்ட்டி ஃபைல் பண்றதும் இருக்கு, அதே மாதிரி எக்ஸ்பர்ட் ஃபைல் பண்றதும் இருக்கு. பார்ட் ஏ, பார்ட் பி.
So as far as electronic evidence, there may not be issue of admissibility. Receive பண்ணதுல நம்ம admit பண்ணிக்கலாம் evidence ஆ. But reliability will be big question. Now 61 ல nothing in this unaimed prevent it from admission சொல்றாங்க. 63 ல certificate வச்சு prove பண்ணணும். 63 certificate வச்சு prove பண்ணணும். So it is going to be a bit challenge for us.